Hello, everyone. Welcome to the class. Today, we're going to have a really quick class because you won't be participating for obvious reasons. So I'm going to try to explain you something that it's really important, that it's the law of the treaties. Okay, basically, what is a treaty, why we sign treaties, who can sign treaty, what's the process of signing treaties. So right now, I'm going to share my screen. And we are going to begin. For what we sign treaties, there's a lot of reasons. For example, trading. Okay, if we are going to have an agreement between two countries with, for example, think about you are going to be my only provider of avocado. Okay, so that needs an agreement. How much am I going to pay? Do you have to pay taxes in here, outside, international taxes for visas? Okay, if I'm having visa for my country, maybe I will make an exception for European Union that it's the case. For example, for the US require visa except for certain countries. That needs an agreement, needs a convention between the European Union. Okay, you have a rule that says we are not going to ask you for your passport because we have free movement with certain like conditions, but yes. Okay, for example, cultural exchanges. If you need diplomatic relations, am I going to have a diplomatic permanent mission on your country? Am I going to have an ambassador, or I will have an ambassador plus consulars? So this is the things that we need to establish in the treaty. We need to make certain rules, written rules. Okay, remember one class we saw the article 38 of the International Court of Justice statute that establishes which are the sources of law. And the first one says international conventions, whether general or particular, establishing rules expressly recognized by the contesting states. We have the international custom that we saw, general principles of law, that is this general rules that many of the times they are not written, but they are recognized by the nations. Okay, and judicial decisions, if you have the court that says, okay, we are going to do this, we're not going to do this, you might use this in order to go to another judgment or in order to do another agreement. Okay, but we're going to focus on the number A, that international conventions. Okay, whether it's general or particular, we talk about this. For example, if we have the Universal Declaration of Human Rights, that's a general convention. Anyone can participate. Okay, any state that wants to join the convention might join the convention. Okay, but we have particular ones. For example, we have a trade agreement between Canada, Mexico, and the US. Okay, in that one, it's a really particular about really specific things. For example, the taxing, the aranceles, things that we are going to do, but only between these three countries. Okay, that's a particular agreement. That's a particular convention. Establishing rules for what? This is every contract, every agreement. What we do is we establish specific rules. Okay, so we establish rules that they need to be recognized. That's why one of the requirements of the agreements is that it needs to be written. But because yes, you can say, okay, I agree, but you, in order to enforce the agreement or in order to make it binding, it needs to be expressly recognized. And with this, the only way for us to prove that it was expressly recognized is to be written with the signature, okay, by the contesting states. In next class, we're going to see what's considered a state, because it's not everything for everyone, okay? So we have as we saw the last class, the Vienna Convention. We have on the 69 a creation of the Vienna Convention on the law of the treaties. It was done in Vienna between in May of 69, but entering into force until the 80. Okay, we have 100 an 11 states party. And basically what they say, okay, we're going to establish the rules of having a treaty. Okay. The first of all, the first principle, and we saw it on class, but the first principle of the law is the pacta sunt servanda. Remember, we talk about pacta sunt servanda. It's basically treaties are binding upon the parties to the must be performed in good faith. Basically, if you're signing, you are supposed to follow the treaties. We have talked this in class, we have discussed. Is this working always or not? Depends. Okay, but this is the fundamental part of a treaty law. Pacta sunt servanda. Everything is binding for the participant states. The thing is that can you force it? Supposedly yes, supposedly no. And this is on the Article 27 of the law of the treaties. Okay, because why would you enter into a treaty if you are not sure that the other state will actually perform its obligation on good faith? If you won't enter to a treaty knowing that you might be suing another country, you might be going to international court with another country. So the thing is that you have to do this we need to have a principle that says, okay, we are going to enter because everyone will actually follow the rules of the treaty. Okay, the definition of the treaties is on the Article 2 of the Vienna Convention of the Law of the Treaties that says, for the purposes of the present convention, a treaty means an international agreement, here we are, concluded between states. Later on, we're going to see, can you have treaties between a state and international organization, for example, between Mexico and the European Union? What do you think? You can have an agreement or not? Or it's between Mexico and each one of the states of the European Union? Okay, so treaty means an international agreement concluded between states in written form. We are going to see, we saw this because we need to be expressly consenting on this and governed by international law. Because if you have an agreement between states governed by a local law, this is private law. This is not public law. Okay, and the state of Mexico is buying, I don't know, material from a specific company in the US. That will be a private agreement because we are going to use a specific law of a country. We're going to do either for the States or Mexico. And we're talking between private parties, okay? So whether embodied in a single instrument or two or more related instruments, whatever its particular designation. When we talk about particular designation, is the name of we use, statute, treaty, convention, consent, whatever we talk. The thing is that sometimes you need more than one instrument. For example, what we call the Bill of Rights, it's not only one document, that is a declaration of the Universal Declaration of the Human Rights, but also we have the Covenant on Civil and Political Rights, and we have the Covenant on Social and Economic Rights. And these three together, it's what we call the Bill of Rights. So the Bill of Rights, it's also a treaty, but made by three different instruments, by three different conventions or agreements. Okay, so these are the elements from this that I already explained them, but these are the elements. It's an international agreement between states that might have a single instrument or two or more related instruments, whether it's particular name that we use. Is entering into treaties a surrender or manifestation of sovereignty? This is a really interesting question that I'm going to make you on Thursday on class, because I think that this is really important. If you are entering, you are forcing yourself to do something that either you agree, yes, but if you don't want to agree in a certain moment, you will have a consequence. Is this a manifestation of sovereignty? We're going to discuss this. Okay, so the formulation of the treaties has two parts. The first part, it's the procedure, okay? the negotiation and adoption of the text of the treaty, what we're going to put, if we agree in everything or not. And the second one is the formal procedure of the states where they express their consent to be binding, to the text will be binding for them. Okay, so we have two parts. So the first one, it's basically the negotiation of the procedure of creating the document. And the second one is when you expressly consent to enter into this agreement. Okay, let me put this a little bit now. Okay, okay. We have many steps. Generally, we put these two parts of the steps, but we have like the signatures and the ratification that it's part of the second part of the formulation of the treaty. So we're going to see each one of those steps, but we are going to divide each one on these two parts. Okay, so making the treaties according to the Vienna Convention of the Law of the Treaties have all these parts. The negotiators, first, you need to see if the person that will negotiate the treaty is a person that has a faculty of actually negotiate the treaty. This is really important because if you send someone, for example, if you send Samuel or a governor to a convention where you are going to sign a treaty, is this person has, what will Samuel need in order to sign a treaty? They will need a special permission, not only because they want to send someone, because if you just send someone, at the end, the state might say, okay, I don't recognize this person. He doesn't have the faculty, he doesn't have the permission of the state to sign treaties. So at the beginning of the negotiations, we need to see if that person has. Okay, there are certain rules. For example, the president of Mexico, they don't need an expressly like faculty because they are the president. Or the Ebrard, for example, that it's on the all the external relations of Mexico, they don't need a specific permission. But if we are sending, for example, if we are signing something about telecommunications or transport, maybe we need someone that is an expert on this. Okay, so we are going to send an expert on this and give them a special faculties in order for him to be able to sign. So at the beginning, we're going to let me see. Okay, yes, we're going to see if that person has a faculty or has the power to sign an agreement. Okay, the negotiation and adoption, we're going to see what is the adoption, the signature, the ratification, if the state needs the permission of their Congress, the entry into force, the registration and publication, what is pacta sunt servanda, and the relation with the international force. Okay, the negotiations might be bilateral, might be regional, or might be by many states. Okay, for example, if you have the agreement that created the European Union, that was a regional. Okay, bilateral might be, okay, an agreement between Mexico and Guatemala in order to avoid the undocumented migration to Mexico. Okay, that's a bilateral. Okay, multilateral is an agreement I already explained, but it's an agreement where anyone can enter and you have many parts on the negotiation. The capacity, I was talking about this. Okay, the capacity of the states to conclude treaties. Okay, in order for a state to enter into an agreement or to sign an agreement needs to have the capacity of being a state. Okay, we're going to see also this next class when we see the subjects of the international law, but we have permanent population. We have a defined territory, okay? We have a specific government and the capacity to enter into relations with other states. This is independence because you might have government, defined territory, permanent population, but you might be in a state that it's dependent from other state. So you need the permission of the other state in order to sign the agreement. Okay, this is established on the Article 1 of the Montevideo Convention on Rights and Duty of the States. Okay, the full powers, this is what I was talking. There's these documents that gives a person or several people to represent the state in order to negotiate and adopt and authenticize the text of a treaty. Okay, and this is, for example, we have this from Philippines. Okay, we have the permission of Jose Perpetuo, a specific permission for this guy, that it's not the president, that it's the air consultant in the air consultant panel. Okay, this is a chairman of the Department of Transportation and Communications that has the permission to negotiate, conclude, sign, execute, and deliver an agreement that it's going to have an effect on the laws of the Philippines. Okay, so you have this specific document. Okay, who doesn't need a full powers? Who doesn't need a document like this in order to enter into an agreement? Okay, we have the heads of a state, of heads of government, or ministers of foreign affairs. Okay, case the president of Mexico, the ministers of foreign affairs will be Ebrard in this case, for the purpose of performing all acts relating to conclusion of a treaty. Okay, also the heads of diplomatic missions. What's a diplomatic mission? For example, ambassadors, for example, consulars. This exception of several consuls, but this is what we call the diplomatic missions. And the third one is a representative accredited by the states to an international conference, to an international conference or organization, or its organs. Okay, this is, and again, this is when you are representing in a specific mission, in a specific international conference, that you were the one designed by the state to do this. In this case, you don't need a full powers. We have the next two steps. Okay, you are able to sign the agreement. You already have the person. What we're going to do, we're going to negotiate. We're going to see, we're going to establish which are the rules, or which are the specifications that the agreement will have. And the next one is the adoption of the text. What's the adoption of the text? Is basically everyone will consent on what is on what the text of the treaty is. Okay, so basically the adoption of the text of the treaty takes place to the consent of all the state of participating, and in international conference takes place the vote of 2/3 parts of the state present and voting, unless the same majority shall participate on the different roles. Okay, so this is the first one. We're going to establish that we're going to make the specific text, and we're going to negotiate. The Article 10 talks about the next one, the authentication. The authentication is a procedure where we all agree on the text. Okay, it's basically we having a text, and we say that this is the definite text that we're going to use. Okay, the text of the treaty is established as authentic and definitive. Okay, everyone say, okay, do you agree this is the final draft of the text? Yes, we all agree, and we sign. Okay, this is like previous the signature, previous the referendum, but this is the authentication of the text. So the adoption is basically we're going to create the text. The authentication is we are going to agree that this is the final draft, or this is the final version of the text. The consent to be bound. This is the conclusion of the treaties. It's the conclusion of the first part. Referendum. We have two parts. The first part of the Article 11 of the law of the treaties provide the consent of the state to be bounding by a treaty may be expressly by signature, exchange of instruments constituting a treaty, ratification, acceptance, approval, or accession by any of the means. Okay, what's the obligation prior into entering into force? Remember, let me show you, for example, you have, you have the Vienna Convention. It was done in 69, but entering into force until the 80. What like rules or duties do you have between these two moments? So the Article 18 talks about this, the obligation not to defeat the object and purpose of the treaty prior into entering into force. Okay, a state is forced to refrain from acts which they will defeat the object of the purpose of the treaty when it has been signed by the treaty or has exchanged instruments or has expressly consent to be bound by the treaty. Okay, so before entering into force, you cannot start doing things that go against this treaty. And the entering into force is usually the rules of how it will enter into force are established in each document. For example, if I'm doing a document that says, okay, we're going to enter into force after the election of the next president. So we have a specific state. Or in 3 months, we have a specific, so this will be established in each one of the treaties. Otherwise, the treaty will enter into force as soon as the consent to be bound by the treaty has been established by the negotiation states, and this is established in the Article 24. Okay, the formulation of reservations. What happens if you like everything about the agreement, but you don't like a specific part? This happens a lot in every one of the treaties. Mexico has a lot of reservations. Okay, the state may, when they are signing, ratifying, accepting, approving, whatever reservation, make several reservation rules. Okay, there's rules in order of their rules to avoid the reservations. For example, when can you not use a reservation? When the reservation is prohibited by the treaty. If the treaty says you cannot have reservation on this treaty, then you cannot make the reservation. This is a little bit logic, but this is okay. The treaty provides that only specific reservation might be made. For example, you cannot make a reservation on the part of the how we are going to solve conflicts. That usually this is the part that everyone has reservation. Every state has a reservation because they won't like to go to a court, for example. So many times we have reservation on this. And in the cases of not failing the subparagraph C and B, the reservation is incompatible with the object and purpose of the treaty. Okay, for example, I will give you an example of a reservation made by Mexico. Okay, this is a convention to suppress the illicit traffic of drugs. Okay, and the protocol. It was on Geneva on the 26th of June on the 36th. When we sign the convention, when we accept the convention, we have several reservations. And one of the reservations is this protocol and this convention has a specific, like, okay, when you get a person that is trafficking with drugs to another country, you're going to give this sanction. Mexico has reservation because they say, okay, we have sanctions that they are more like strong sanctions. They're like bigger sanctions. So in this case, I'm not going to use your sanctions, but I'm going to use my sanctions. Okay, so in this case, Mexico has the right inside their territory to have more harsh sanctions to people doing this, more harsh than the ones established by the convention. Okay, The next one is the acceptance of and the objections of the reservations. So, okay, if I have a reservation on the convention, does every state needs to agree on this reservation? Yes or no? Okay, so the reservation will be expressly authorized by the treaties when they don't require any subsequent acceptance by the other treaties. When there's a limited number of the negotiation states that says, okay, we all need to establish certain rules, and these rules are going against the treaties, then in this case, the facts or the conditions of the treaties, in this case, the reservation will require an acceptance of all the parties. And when the treaty is it's an instrument that it's creating an organism or it's creating something, the reservation will require the acceptance of the competent organ or the organization. Okay, so unless the treaty provides another condition, the reservation is considered to be accepted by the states when they haven't raised objection. Okay, so basically you say, okay, I don't like human, for example, this reservation of the Geneva Convention on the illegal trafficking of drugs. Okay, so Mexico establishes, okay, this will be my reservation. So you don't have to go with each of the countries. Do you accept my reservation? Do you accept my reservation? No, what we are going to do, we're going to give a moment of 12 months after the notification of the reservation. And if no one raised an objection to this, we are going to get as accepted the reservation. The next one, the next part that is on the second part of the treaties is the registration. And this is to ensure the transparency of the international relations. The Article 102 of the UN Charter says that every treaty and every international agreement will enter into force by the member of the United States need as soon as possible register to the Secretariat each of the agreement to be published. So if you are part of the UN, you need, in order to have like peace and international agreement, you need to register your convention, your new treaty. The thing that the failure to register a treaty has no effect on the validity. So if you don't register the treaty, doesn't mean that it's not valid. So what's the need? Like, why do states need to register if there's no consequence of registering it? This is basically because we follow the rules. Okay. And to avoid, and this is the article says, that Article 102 of the Charter says, this is to prevent the states from entering to secret agreements. We already said, okay, this happens a lot. Okay, this secret, it's not that they are secret, but they don't want to tell everyone. Okay, without the knowledge of the secret agreements, without the knowledge of their national and without the knowledge of the other states. This is another one. It's not about only about the other states knowing about your agreement, but it's also about the people inside your territory to know that you entered your agreement. For example, I have an agreement in order to let coffee companies to enter into Mexico for free. The agreement between Kenya and Mexico in order for Kenyan companies to enter, coffee companies to enter into Mexico. Okay, imagine the people that work in the coffee company in Mexico, they need to know that now you're going to have more people to compete with from another country and you have no idea. So also the people from the states, they need to know. So we try to avoid this. Secret diplomacy has condemned since the League of Nations. Remember, we saw the League of Nations. And this is to be noted that secret agreements are not unlawful. And although they are disapproved and difficult to conceal, they still exist. We still have secret agreements because at the end it's agreement because we have the two states that they're consenting and they are agreeing The next one, we have the UN Treaty Series. After you registered your agreement, it will be published, okay, in the UN Treaty Series so that everyone can consult it. So you can right now go and put Mexico on the UN Treaty Series and see all the valid or all the convention that has been signed by the UN. The applications, okay, the non-retroactivity of the treaties. What is this? Okay, unless a different intention appears on the treaty, there's no binding in relation to act or fact which took place or any situation which it ceased to exist before the day in to enter into force the treaty. Okay, you cannot you cannot punish a treaty for something they do before entering into force of the treaty. Okay, this is basically what happens with the laws. This is the principle of law that we saw in class. You cannot punish for something done before the rule is established. Okay, and the Article 29, that is the territorial scope on the treaties, is unless something is established on the treaty, each party will respect this treaty on the entire territory of the state. Okay, what happened? Can we apply a treaty to a third party? Okay, there's an agreement between Mexico and Kenya will be applied to a third party. This is on the Article 34 of the Vienna Convention on the Law on the Treaties that says it's only between the parties, so it has no effect on a third party. However, there are exceptions for this. For example, if a treaty imposes an obligation on a third party and that treaty provisions will become binding on a third party, this it will only apply when it's customary law. Okay, and so only the part of the customary law. Remember, we saw on the case of Nicaragua the customary law. So this part will be binding for a third party. And if the treaty confers a right to a third party, that must consent on it. Okay, so for example, we have an agreement between two countries and we say, okay, if we have a disagreement or we have a conflict between the parties, it's between Mexico and Guatemala. If we have a conflict between Mexico and Guatemala, we are going to establish that El Salvador will be the one trying to solve or will be the one on the mediation or help us solve the conflict between the two states, but we still need the consent. So all the treaty doesn't apply to El Salvador, only that small part, and still we need the consent, the consent of the state. And the interpretation of the treaties. Okay, so basically it's by good faith in accordance with the ordinary meanings of the terms, according to the context and the light of the object and purpose of each one of the treaties. In order to avoid this, what do they mean with treaty? What do they mean with illegal drugs? Because for you, this is an illegal drug, but for me, this is not an illegal drug. So usually on the beginning of a treaty, we have the use of terms. Says, for example, this is an example of a treaty. For the purpose of the present convention, treaty means all the international agreements. Ratification, accept, and approval is this. Full powers will mean this. Reservation will mean this, and so on. Oh, sorry. Okay, and the termination of suspension of the treaties. Okay, the principle of pacta sunt servanda and good faith entail the state cannot release itself from the treaties whenever you wish. It's not like, okay, I don't want to be part of this treaty because you have agreed with this treaty. You have this rule that it's called pacta sunt servanda and good faith. So we have several circumstances where the termination can be done. It's whether a treaty is suspended and still it's valid. for the operation when it's suspended temporarily, and when the treaty is terminated, it's no longer in force for the endings of the existence. Okay, so many times, for example, the termination of the suspension, it's provided that by the specific state. So we sign a specific state or the specific convention. For example, we're going to sign the TLCAN, the NAFTA. So in this case, we said that the treaty will end, will finish, will be terminated or will finish in force on 2020. So we established the specific date of termination. Okay, most treaty contain the provisions on termination, and termination provisions are usually closely linked to the duration of the treaty. Basically, how much will the treaty last? So there are fundamental changes of circumstances. Okay, this happens, for example, occurred when regard of those existence and time of conclusion of the treaty and has not foreseen by the parties. What happens if a state disappears? Okay, if the state disappears, you cannot force the new state, and we're going to see this next class, to enter into a force because it's a new state. So the circumstances have, these are cases where you have, for example, a termination. Okay, also the impossibility of performance. You have a convention between Mexico and Kenya to provide Kenya of avocados, but we have a crisis of avocados and they extinct, and you cannot produce avocados. So it's impossible to execute this treaty. So in this case, you have the impossibility of performance and the treaty will end. Okay, according to the Article 70 of the law of the treaties, the termination of a treaty releases the party from the obligation. So the moment when it ends, you don't have to follow the rules again. Okay, and sorry, this is an activity that we cannot do because we are not in class, but hopefully you get. This is like try to match the parts of the trees. Okay, thank you everyone, and see you very, very soon in like 4 days. Bye.